Hi there, I'm Christine, and this is the Freedom Update, the monthly video podcast from the Canadian Constitution Foundation, where we talk about our ongoing cases, give updates about interesting constitutional developments from across the country, and give you information about how to join us for our upcoming events. Thanks for tuning in, and let's talk about freedom. May is an exciting month at the Canadian Constitution Foundation. We're going to court on Wednesday, May 12th on a fascinating case related to civil forfeiture, and we're launching a new case. I'll start with our newest case, which involves a man named Robert Bristol. Mr. Bristol is opposed to the extremely strict lockdown that's taking place in Ontario, which he believes is unnecessarily hurting small businesses. Mr. Bristol isn't anti-science. He wears a mask and he believes that COVID is real. He just doesn't agree with the severity of the lockdowns. You know, it's a pretty common and reasonable objection to government policy. Mr. Bristol decided to protest against these lockdowns. He went by himself to Kingston City Hall with a sign opposing the lockdowns. He was alone and he was wearing a mask. While he was standing outside by himself in a mask, Mr. Bristol was approached by two Kingston municipal police officers and issued a ticket for failing to comply with the province's stay-at-home order. Mr. Bristol filmed the entire interaction. The officers told Mr. Bristol that protesting is not a permitted activity under the stay-at-home order. He pointed out that he was all by himself, there was no one else at this protest, and that he was wearing a mask, but he was still issued a ticket. His summons is for June 7th, and this is when the amount of his fine will be set. While we at the CCF don't usually get involved in individual ticket cases, we think that this story is just too absurd not to get involved. We're going to be helping Mr. Bristol to fight his ticket, and we're also going to be challenging the stay-at-home order and its failure to create an exemption for outdoor protests. There was a similar case that was brought in British Columbia, and in that case, the prohibition on outdoor protests was struck down. The court found that the prohibition on outdoor protests was an unjustified limit on freedom of assembly and freedom of expression. This is an important case for freedom of assembly and expression and the right of the public to protest against government policies. COVID doesn't spread easily outdoors, and if the government can use this as a reason to limit protests of their policies, they could just as easily limit protests for creating other slightly risky scenarios. For example, there's a risk of public disruption or even violence at many protests. This risk is actually probably higher than the risk of spreading COVID outdoors wearing a mask alone, as Mr. Bristol was in this case. Is that a justifiable reason for governments to prohibit protests in the future? Of course not. You can learn more about this case and how you can get involved by visiting the ccf.ca. Now, as I mentioned, we're also going to be in court on May 12th on a really fascinating civil forfeiture case. Civil forfeiture is a process that allows government to seize property and other assets that are tainted by crime. These laws exist across Canada, and in Ontario, civil forfeiture is governed by the Civil Remedies Act. Civil forfeiture laws were originally intended to deter crime and to compensate victims, and many members of the public are not really bothered by these laws because they consider them something that only affects criminals. But unfortunately, civil forfeiture laws actually allow provincial governments to seize property not only from criminals, but also from people who have never been charged with or even suspected of a crime. Typically, all the government has to show is that the property at issue was used by somebody, anybody, as an instrument of crime, or was the proceed of crime. And in the case that's being heard in Ontario at the Court of Appeal on May 12th, the government's now arguing that they don't even need to show that. The case being heard is called Norwood Estate and the Attorney General of Ontario, and it involves a kind of unusual set of facts and a little used provision in the Civil Remedies Act. It involves a man now deceased. His name was Michael Norwood, and he was arrested and charged with some drug-related offenses. His property, including the family home, was seized by the federal government at the time of his arrest. The property was restrained and sold, but Mr. Norwood later died, and the charges against him were vacated without a trial. Following a few interim proceedings, the Superior Court ordered on consent that the funds from the sale of the home be released to his estate. Now, this is where things got a little bit sticky. A week after the order of the return of the funds to the estate, the Attorney General of Ontario stepped in. Now, the Ontario Attorney General had not been heard from before and delivered a notice of application for forfeiture of the money under the Civil Remedies Act. But the Ontario Attorney General's application for forfeiture never proceeded past the bare notice itself. Instead of proceeding with a forfeiture using the standard steps that are laid out in the Civil Remedies Act, the Ontario Attorney General proceeded to use a new and a little used provision of the Civil Remedies Act to sort of sidestep the forfeiture proceedings and deplete the assets completely. Section 18.1 of the Civil Remedies Act allows the Attorney General to enter into court-approved settlements with third parties who have what's called innocent interest in the property. In this case, Mr. Norwood's mother, Rosa Norwood, claimed a partial interest in the family home. But Rosa Norwood's claim to the home was disputed by the estate. Nevertheless, the Ontario Attorney General entered a settlement with Rosa Norwood over the objections of the estate, and that settlement was approved by the court. The case is now at the Ontario Court of Appeal, and the court will consider whether they can approve a settlement under this section of the Civil Remedies Act prior to the determination that the funds were proceeds of crime. And our view is that they cannot do that. We are intervening in this case to argue that this novel interpretation of Section 18.1 is inconsistent with the purpose of the Civil Remedies Act, which is intended to prevent crime and compensate victims. The lower court's interpretation would effectively remove any burden the Act places on the Attorney General to tender evidence that the asset was actually tainted by crime. And it would permit the Attorney General to sidestep the requirements of the Act by disposing of any assets as they see fit, as long as they can arrange a settlement with a third party. Civil forfeiture is a powerful tool, and because of the power that the Civil Remedies Act gives the government to seize property without compensation, the limits on how this tool may be exercised must be clear. Norwood Estate creates an excellent opportunity for the courts to clarify those limits. We'll be sure to keep you updated on this case. Keep watching these video updates and subscribe to our mailing list at theccf.ca to stay up to date as things develop. There are some interesting constitutional cases from across Canada, and this week we're checking in with the federal government and the chaos around their new proposal to regulate social media. The new federal bill to regulate social media is still under development, but it's called Bill C-10, and it's attracted a lot of attention recently. The bill was introduced last November and is called an Act to Amend the Broadcasting Act. It's meant to update Canada's broadcasting legislation so that internet streaming giants like Netflix will also fall under the regulation of the CRTC. But last month, the Liberals on the committee reviewing the bill amended it and removed a section that would have excluded user-generated content from regulation. This amendment led to many legal analysts, myself included, to express concern that this is opening the door to regulation of user-generated content. We don't want the government asserting that they have a right to regulate TikTok videos and Instagram videos published by users. This would be an undue and likely unconstitutional violation of the right to freedom of expression. The government has somewhat retreated by saying that they're going to amend the bill, but fiddling around the edges isn't enough. The Heritage Minister needs to go back to the drawing table with this legislation, or he's going to be facing a legal challenge once this bill becomes law. I have an exciting upcoming event that I'm just thrilled to tell you about. It's the digital launch of a new book that I have co-authored with some individuals from organizations across Canada who are involved in the public policy and individual liberties movement. The book is called Life After COVID, and I've written it with my friends at Second Street, the Canadian Taxpayers Federation, the Justice Centre for Constitutional Freedoms, and the Montreal Economic Institute. We're releasing the book later this month, and I'm going to be offering it for free to all viewers of the Freedom Update for download as an ebook. I'll have more details to share when we have our release date set, including a virtual launch party. So to get your invitation to the launch party, visit theccf.ca/lifeaftercovid, put your email address in, and you'll get an invitation to the event once we have the date scheduled. That's all for this update. Thanks for tuning in, and let's keep fighting for freedom in Canada.